Thank you for joining this screencast. My name is Matthew Allen. I'm the co-founder and CEO of Social Security Advisors. And in this screencast, we're going to be covering the major changes occurring to Social Security as a result of the Bipartisan Budget Act of 2015 and what these changes mean for you. To give you a brief overview of Social Security Advisors, we're an innovative financial and technology company with a single mission, which is to help our clients maximize their Social Security benefits. Basically, as a result of the complexities in terms of how to claim and when to claim Social Security benefits, most Americans and especially couples fail to optimize their Social Security, and as a result tend to leave on average about $120,000 per couple on the table as a result of failing to optimize their benefits. Basically, we fill this void by providing customized Social Security advice through our online software at socialsecurityadvisors.com and also through our highly trained team of Social Security specialists. To get into the brief history here in terms of what's changing under the Bipartisan Budget Bill of 2015 and why some of these things are happening, I'll start first with a few Social Security facts. Number one is that there are 2,728 rules governing Social Security. So it's an extraordinarily complex program. And again, figuring out when to claim and how to claim to maximize benefits is a complex decision. As a result, roughly 70% of Americans fail to maximize their benefits, and in total per year, that's about $25 billion every single year that's left on the table. There are typically over 9,200 different ways to claim Social Security, and additionally, finding credible guidance is generally quite complicated, specifically because the Social Security Administration is by law prohibited from providing advice. So turning back to the Bipartisan Budget Bill of 2015, which was signed by the President on November 2nd, this basically, in addition to the overall budget, it actually included a provision eliminating two popular Social Security claiming strategies, which we will talk further about in this screencast. These strategies in general and Social Security planning overall has increased in popularity in recent years because more and more Americans, also more financial advisors and CPAs, are starting to recognize that there's smarter ways to make decisions when it comes to their Social Security as opposed to just claiming at 62, 66, or 70, or somewhere in between. There are many spousal benefit strategies and survivor benefit strategies that are available that can maximize Social Security benefits, and combining these strategies in the right way is the complex issue. In terms of the two popular Social Security claiming strategies that are being eliminated, they really were essentially created and came into being primarily as a result of the Senior Citizens Freedom to Work Act of 2000. That was a separate bill that went into effect accordingly. And basically what this allowed for is it allowed for Social Security beneficiaries to start collecting some Social Security benefits while also receiving delayed retirement credits, which had the ability to increase their benefits in the long term. So getting into some of the two strategies that are being affected, there still will be many other strategies available going forward, however, just to point that out before getting into the two that are being eliminated. So Social Security planning is continuing to be a very important aspect of retirement planning, and especially because the typical American couple can expect to receive over $1 million in lifetime benefits from Social Security. So the first strategy that is being affected by this budget bill is what's known as file and suspend, and it's going to be ending effective May 2nd of 2016. I'll cover a bit about the strategy, the upcoming change, why it's important, and again, the important deadlines to keep in mind. So first of all, in terms of the strategy, basically file and suspend gave one spouse the ability to file for benefits but then immediately suspend them, while his or her spouse then started claiming a spousal benefit based on that record, while letting the benefit continue to grow for the primary filer at the rate of 8% a year up until 70. Under the change, basically what's happening is that if benefits are suspended, all benefits payable to a spouse or other dependents will also be suspended, and that essentially will eliminate the ability for the spouse to receive a spousal benefit if, in fact, the primary filer has suspended benefits to try to accrue delayed retirement credits. So the change also eliminates the ability for the filer to request a lump sum benefit payable back to the date when benefits were suspended. Under the old rules, or the rules existing up until May 2nd of 2016, what can happen is that the filer can actually suspend benefits and then say at 66, because they have to be full retirement age, which is 66 for most people, that they could suspend benefits at that point, and then let's say at 68, unsuspend those benefits and receive a lump sum benefit for those 2 years that have been suspended. Under the new legislation, that is effectively going away. That ability to get that lump sum is effectively going away for those that attempt to do this after May 2nd, 2016. So with respect to why this is important, again, the ability of a spouse to claim the spousal benefit while also getting the delayed retirement credits is effectively going away. So that's very valuable for many couples, oftentimes $50,000 to $60,000 in benefits. And when combined with the second strategy that is being affected, which is the restricted application strategy, it can be about $120,000 on average for the typical couple. So again, just the important deadlines to keep in mind. Those that are receiving benefits already will continue to receive them. That's the first point. The second point is those that are not yet receiving benefits must be at least their full retirement age, so again 66 for most people, and must file by May 2nd, 2016 in order to be grandfathered into these existing rules, the rules prior to the legislative change. To speak a bit about how this is going to affect folks based on their marital status, for singles, all singles 66 and over by May 2nd, 2016, specifically 66 and over, but under 70, I should say, should consider filing and suspending. This will give them the ability to preserve that ability to receive the lump sum benefit if desired, and it will be very beneficial for singles that fit that criteria to be thinking as to whether this can be to their advantage, and important to do the analysis to determine that. For married couples, basically all married couples with at least one spouse that is 66 to 70 need to consider whether filing and suspending would be beneficial for them as a couple. And married couples, I want to highlight this specifically, that married couples have the most to lose by failing to consider these strategies prior to the deadline. So it's very important to determine whether this is correct for your circumstances. For those that are divorced, all divorced individuals 66 and over but under 70 by May 2nd, 2016 should also consider filing and suspending. Again, similar reason to singles, and that is to try to preserve that lump sum benefit option if desired. Importantly, under the new legislation, survivors are unaffected by this new legislation. Having said that, however, they will continue to have many Social Security options available to them, because they can receive, for instance, a benefit on one record while continuing to accrue delayed retirement credits and then claim on the other record at a later date. The second strategy that is being impacted is what's known as the restricted application. And basically this is ending for those that are born in 1954 and after. So to talk a bit about the strategy, filing a restricted application at full retirement age or later allows the filer to file only for spousal benefits, which can be worth up to 50% of his or her spouse's full retirement age benefit. And in addition to that spousal benefit, it can also let their own benefits on their own record continue to grow and accrue delayed retirement credits at the rate of 8% a year. So it's a very valuable strategy to be considering and to be taking into account and trying to determine whether that is best for your circumstances. Under the change, what's happening is that With the exception of those that file for or are filing for survivor benefits, anyone born in 1954 or later will no longer be able to file a restricted application for spousal benefits only. And this is due to something called the deemed filing rule, which is going to apply with this new rule change. And basically what the deemed filing rule means is that if one files for Social Security benefits, what Social Security will look at is what eligibility they have for any benefits, whether it's a spousal benefit or whether it's a benefit on one's own record, and Social Security will pay out the highest benefit to which they're eligible. So with the new change, those born in 1954 and later will not be able to only restrict their application to spousal benefits only. Again, another way to look at the important deadline is basically that you need to be at least 62 by December 31st of 2015 to be grandfathered into the old rules. Again, to talk about the restricted application by marital status, basically for singles, it's not a valuable strategy because, and they're essentially going to be unaffected by this change because it's only valuable to those that have been married. For married couples, though, it's extraordinarily valuable. It's something that needs to be considered carefully. And all married couples with at least one spouse that is at least 62 but under 70 and that has not already claimed benefits on their own record need to consider whether the restricted application is appropriate for their circumstances. In doing so, it can be worth, in many cases, $50,000 to $60,000 in additional lifetime benefits. And when combined with a file and suspend strategy, again, that tends to be upwards around $120,000 in lifetime benefits. Those that are divorced actually have very similar considerations as a married couple in a way, and need to strongly consider the options available to them. Basically, all divorced individuals born prior to 1954 that have not already claimed benefits on their own record should highly consider and evaluate filing for a restricted application. And again, that would preserve the ability to get a spousal benefit while also accumulating delayed retirement credits on their own record. The timing, of course, of doing this, again, is critically important, figuring out when to file that restricted application, if to file the restricted application, etc., needs to be evaluated carefully, but it's often, again, worth $50,000 to $60,000 in benefits that those in this position would otherwise not receive without properly filing, for a restricted application. Also similar to file and suspend, survivors are going to be unaffected by the new legislation. However, they, again, are still going to have many options available to them. So in terms of what you should be doing now, it is really critically important now more than ever to be talking with and consulting with a Social Security advisor to make sure that you know how to maximize your benefits, and whether any of the strategies that are highlighted in the screencast are right for you or not. It really does require a careful analysis of each situation. Each individual and each couple is very different and has different considerations and different strategies available. So crunching the numbers and getting that right is critically important. Again, the Social Security Administration by law is not allowed to provide advice, and many financial advisors even and CPAs often don't have the Social Security expertise that is really required in order to implement these strategies in an effective way. So if you do want some assistance, we are of course very willing and able to provide that to you and provide that expert guidance. We have plans on our website at socialsecurityadvisors.com/start that range anywhere from $24.95 to $124.95 per plan. Those plans, by the way, for married couples, that does cover the couple, and they're all lifetime plans as well. So if you have questions in the future, if you purchase the $124.95 plan, which is the premium plan, that's what gives you the ability to speak with an advisor and with that lifetime plan you can call back with any future questions in addition to receiving your initial report covering what is the best way to file and how to file for your Social Security, plus also your advisory session talking with your advisor and going through your best options, not only what's your best strategy, but what is your second, third, fourth best option, etc. Additionally, because some of these strategies are more difficult to implement, and just to save our clients time, we offer our filing service, our Social Security filing service, so we will actually do the filing for you for a modest filing fee of $99.95 per filing. Again, that gives you the expert guidance, of course, in addressing the Social Security application and filing in the best way and the proper way in order to implement the strategy that you're seeking to implement to maximize your benefits. And it's obviously the best way to avoid costly mistakes and saves you a tremendous amount of time and hassle in many cases versus trying to call the Social Security Administration to implement these strategies properly, or going down to a local office to try to do this as well, which can be quite complicated. So to again quickly review the pricing plans, there's a basic shot here of them, again ranging from $24.95 to $124.95, and we do have the Social Security filing service and also Medicare advice available as well for those that are having questions and issues with addressing what's best for their circumstances with respect to Medicare. So you can sign up if you have an interest in receiving assistance. You can sign up at socialsecurityadvisors.com/start. If you would like to speak with an advisor for an initial consultation, which is free of charge, you can either call 1-877-MAX-MY-BENEFIT, option 3, or you can visit our website at socialsecurityadvisors.com, and there is a live chat feature on the website as well, where you can certainly ask some questions and receive some preliminary answers and help from our advisors. Lastly, another great way to reach us is via email, which is clientservices@socialsecurityadvisors.com. If you would like to read more about the changes under the new legislation, you can do so at socialsecurityadvisors.com/changes. And if you're interested in the filing service specifically, you can also visit our website for the filing service, which is applyforsocialsecurity.com. Thank you very much for tuning into this screencast, and we look forward to assisting you.